Should an indigent defendant charged with property damage solely upon a witness identification made by the property owner be allowed a court-appointed expert to testify on the inherent weakness of eyewitness testimony? That was the question in the case of the broken windshield. On the night of the offense, the victim identified two defendants as the persons he believed he had observed breaking his windshield. This identification was made to police at the victim's home after the suspects had been detained by the police based upon a prior description by the victim. At trial, the victim generally testified to the same factual scenario as he did at the suppression hearing. Further, he testified that he had identified one of the defendants to the police as one of the persons who had damaged his car, and that he had relied upon his previous out-of-court identification, mainly upon the identical clothes match. The victim, however, would not make an in-court identification of that defendant. The defendant's defense lawyer had contacted a practicing psychotherapist for the purpose of testifying to the general reliability of eyewitness testimony, and specifically the influence of stress, suggestive information, and cross-racial identification upon the victim. Counsel for the defendant believed that if allowed to testify, the psychotherapist would have been able to assist the jury in evaluating the reliability of what the victim believed he had seen, how he had retained that information, and how he had explained the information. The defendant made a motion to appoint an expert witness to testify as to the reliability of the identification of the suspects by the victim. The trial court denied the motion. The defendant was convicted. The defendant appealed and argued he did not receive due process. How would you decide this case? Should the defendant have been allowed an expert to assist in his defense? We'll be back in a moment to answer that question. Was the trial court correct in denying the defendant an expert to testify on the reliability of eyewitness testimony? Yes, said the South Dakota Supreme Court. The Supreme Court noted that the defendant did have an investigator appointed at county expense, and that the victim's out-of-court identification was the subject of vigorous cross-examination by the defense lawyer. Finally, the reliability of the identification was not beyond the understanding of a layperson. The jury knew that the crime occurred at night, that it was difficult to see, and that the identification was mainly based on a clothing match, rather than facial appearance. Even though the victim could not make an identification in court of the defendant, expert testimony was not necessary because the evidence was not beyond the understanding of a layperson. Remember, it's a matter of law.